Welcome to the e-discovery, an intro to digital evidence. This is the last chapter, chapter 9. This chapter deals with the future of e-discovery, and more specifically, it deals with some of the challenges. We're going to summarize new developments in the nation and international privacy laws, explain how technology affects the rights of individuals, and describe the effect of anti-forensics on e-discovery procedures. So let's revisit privacy. So laws regarding privacies, one of the big issues is they're not able to stay up to date. They are constantly changing, constantly adapting, and one of the issues with that is the technology is outpacing the laws. So we have privacy issues when dealing with like wiretaps or eavesdropping or just checking personal email. Because of things like the internet, we have more concern with like email and voicemail and mobile technologies like iPads, iPhones, smartphones, smart TVs, smart devices, IoT devices, things of that nature. It can include areas such as cloud. Where is the information actually being stored at, and in what jurisdiction is that data or those resources tied to? Or social media. Social media is a whole new area. So we actually have what's called the Electronic Communication and Privacy Act, ECPA, and the Stored Communications Act, SCA, and they do grant privacy for email. Though it's not a true guarantee of privacy, there is some privacy there. Each U.S. state has privacy laws that can affect what's allowed to be collected. We have state law and we have federal law. And most of this is done at the state level. California has the most detailed laws on digital investigations. It's kind of interesting. It is one of the larger states. It has a very large population, so that kind of does make sense. And this has started creating templates for use in e-discovery cases. That way, it's not just anything. California very specifically has a certain structure and flow. Northern Districts of California published a checklist specifying that parties aren't required to send a preservation letter, but if they do, to ensure the scope is not too broad. Again, it goes back to what is allowed and what's not allowed, or what's expected. Other states will probably follow these guidelines, but it's going to take time. We also have what's called the Online Communication and Geolocation Protection Act, OCGPA. This is a new bill that was proposed by the House of Rep as a result of the Perpetual scandal. I can't pronounce his name. But the famous general scandal, as an amendment to the ECPA that severely restricted tracking citizens by use of their GPS in their mobile devices. So again, we know that we're being tracked. It's just more of a what's allowed and what's legally allowed. That's the issue here. Law enforcement would have to get a warrant for all electronic communications regardless of age. The U.S. Department of Justice is challenging these limitations because this could hamper, very specifically, certain criminal investigations. Personal Information Protection and Electronic Document Act, PIPEDA, came full effect 2004 in Canada, requires organizations to notify people when personal information about them is being collected and or disclosed. This also gives the people the right to see any of the recordings and make corrections if necessary. So that's a key thing here, is making available the recordings. That means they have to know who's collecting the data on them, and that again could affect or hamper an investigation. Canada does not have laws specifically for email privacy. It's more just a broad electronic. There are multinational corporations, and they need to be aware of the laws in the countries that they operate in. because each country has different laws. Each country has penalties for privacy violations, and they vary widely. Some corporations have employees in each country who specializes just in privacy laws. We actually have cybersecurity lawyers that deal just with cybersecurity. New and proposed iOS standards is the ISO 27037 in 2012. This is the information technology security techniques, and these are the guidelines for identification, collection, acquisition, and preservation of digital evidence. And this is part of a new iOS standard created in 2012 to help set more specific guidelines for digital evidence. It is geared towards forensics investigations, but the collection methods it describes can be applied to civil cases as well. Attempts have been made to standardize these practices, though they're not always as straightforward as one would want. So one of the other challenges is there are no standardizations, so standard qualifications don't really exist, such as a requirement for education or years or type of experience. It's just kind of anyone can call themselves a forensic specialist, and there you go. Though several states do require digital forensics investigators to be licensed as private investigators. Annex A of the new ISO standard does specify certain skills called DEFR, D-E-F-R, or Digital Evidence First Responders, to kind of help combat this. As a result of the iOS standards on digital forensics, a new proposal for iOS standards on e-discovery has been approved. That's going to be the iOS IEC 27050, and that is the Information Technology Security Techniques for Electronic Discovery. Keep in mind, these are ever-evolving, ever-changing. If we're looking at a global GPS, Global Positioning System device, to track a suspect has become very common. However, there are some issues with this. For example, a recent court case, United States versus Knotts, where a tracking device was placed in a container defendants had purchased. The case was appealed on the grounds that the information collected from the tracking device did violate the defendant's Fourth Amendment right. However, the tracking device only argued what officers could observe while following the defendant's car. However, the conviction was upheld. So that's an example of how a GPS court case could be reviewed. We also have United States versus Caro, where the law enforcement planted a tracking device in a container of ether. After the container had entered the private property, the tracking device violated the Fourth Amendment right. So on the private property, a warrant is required to use a tracking device. Many organizations, so there was an issue with that one, because as it entered the private property, then the tracking devices was null and void. So again, there's concerns there. The effects of new technology. Many organizations will have policies that anything connected to their network can be searched. So you connect to Wi-Fi, I agree, not understanding that you are giving permission for your device to be searched. This policy can be applied to mobile devices, issued by and paid for by the employer, or even purchased by the employee because you're connecting to their resource. Specifically in the U.S., if an employer purchases a device and an employee signs an agreement for its use, the employer can search data on the phone. While in other countries, this may not always be the case. A device type and age affects whether data is stored on the device or whether it's stored with the service provider. Cheaper, more basic phones store text messages and SMS messages on the device, where voicemail may be stored on the service provider. So accessing voicemail would require a subpoena or a warrant to the service provider. Service providers may only save voicemails for a certain time. They may not have a lifelong commitment or a 20-year commitment or 5-year commitment. They may store them for 12 months. Again, service providers are going to vary depending on the type of service provider. Depending on the service provider and the type of device data, again, understanding that the type of data where it's stored at is going to be different. Smartphones, however, voicemails are stored on the provider's server. Text messages are stored on the device. Emails are stored on the device. File attachments can be stored on the servers, cloud storage, or on the mobile device. So again, it's not always on the device or the service provider. Once we start entering smart devices, there's a whole new cloud component to this. What gets really interesting is when you talk about mobile devices, the whole BYOD, bring your own device, and now we're talking about BYOA, which is bring your own application. And that's going to be applications that are installed on your mobile device, and then how those applications could pose a security risk to the network that your device connects to. The applications might be recording data usage, recording information, recording phone calls, all different types of components. So, that is one of the issues when we start installing applications on our mobile devices, is seeing kind of what they do. If a mobile device is loaded with these applications and are connected to a corporate network, what can they take from the corporate network? Again, sometimes these applications could be malware. An officer is allowed to search an arrested person and his or his intimate surroundings with the suspect's control or reach. Arizona versus Gant. Gant's car was searched after he was handcuffed and placed in a police car. The Supreme Court threw out the products of the search. With Grant in the squad car, police had no grounds to search the vehicle because it was no longer part of his immediate surroundings. Search incidents to arrests means an officer can search anything the suspect or the arrestee have in their possession and their immediate control. Chima versus California. Police had a warrant for Chima's arrest. They searched his home after his wife objected. The search was a violation of the Fourth Amendment right because searching the house did require a separate warrant because Chima wasn't there and because the wife had objected. Again, this was about their possession and in their immediate control. If Chima was there, that's different, but Chima wasn't there. Can law enforcement search a person's phone or the phone content? Can law enforcement require an individual to unlock their mobile phone? And that's an issue. We have two issues here. We have the inventory searches and the closed container searches. In South Dakota versus Opperman, Opperman's car had been impounded for illegally being parked. When the car was towed, they found pot in the car. When Opperman came to claim his vehicle, he was arrested. Would that be a legal arrest? So, again, there are some concerns here that are not always as black and white as people think. Computers have been treated as closed containers for a legal sense. So similar to filing cabinets or a plastic container, mobile devices also fall into this category. So having to forcefully require a suspect to unlock their device may or may not always be allowed. Because people carry their mobile devices on them, tracking a mobile device and listening to it as part of inventory is reasonable. Does that mean searching the device content is reasonable? And again, that's probably one of the issues that we're having now is understanding the different laws dealing with our technology and if they're considered reasonable or not. The state Supreme Court of Iowa ruled in 2009, police are obligated to obtain a search warrant for searching data on a cell phone. When the search is not necessary to protect the safety of law enforcement, there are no extenuant circumstances, while the Oregon Supreme Court made a similar ruling in 2012. Mobile device seized as an incident to an arrest. Is law enforcement officers in danger? If no, warrant needed. If yes, warrantless search is allowed. Is there possible destruction of evidence? If yes, warrantless search is allowed. If no, warrant is needed. Or if there's extenuant circumstances, if yes, warrantless search is allowed. If no, warrant is needed. More and more organizations are coming up with these flowcharts to understand what is and what is not allowed. More states are coming up with these flowcharts as well. What about e-discovery when dealing with social media? In Europe and other countries, personal privacy has precedence over corporate rights. So data retained by social media sites has become a privacy issue. Like a law student launched a crusade against Facebook for illegal practices, claimed that Facebook collects and markets data without users' consent. The case caused more than 40,000 EU citizens to demand their Facebook files. Again, huge lawsuit, huge amount of issues dealing with Facebook and the EU. EU countries are trying to control Facebook's use of tracking cookies because this constitutes a violation of privacy rights. A bill named Cookie Law was proposed by the European Parliament, and this would require companies to delete old information in a timely manner. Companies transferring personal data across borders could also be fined 2%. Though companies transferring personal data across borders gets very subjective because, again, where's the data truly being stored at, and how do we define transferring between borders? Just because you're accessing the data in a different country doesn't mean the data is being transferred. So again, there's some issues with this. Companies that use Twitter, Facebook, and other social media are part of doing business should develop their own policies. These policies need to protect the employee privacy, the accounts, and understanding the laws where these websites are being accessed. Companies have been censored for requiring employees to friend them. So again, there's some issues here. Students are cautioned that posting their social exploits online could ruin their careers. Again, if you have sex or you're in a committed relationship and you post nudes, all of that can cause long-term damage. What you post on social media can cause damage. The fun part is, government and law enforcement also use social media to investigate people. A woman bragged on Facebook about being a tax fraud pioneer and was later charged with tax fraud. Federal investigators of gang members have resulted in convictions based off of information put on their Facebook, MySpace, Twitter, so forth. What you do online stays online. People can see that, so keep that in mind. Other ones would be like Google+, which is another major social media site. Would these meetings be considered discoverable in e-discovery? Would recordings of them be covered under the Wiretap Act? Should companies educate employees on how to use these devices? Or should they worry about creating policies about conducting meetings using these tools? Twitter is another great example. A link to it was placed in the U.S. Embassy in Cairo. When the Egyptian government took offense, the Twitter feed was shut down. If employees post tweets about supervisors or customers, does retrieval material in an investigation violate privacy rights? How do social media and review of social media violate privacy rights, or do they? How long should government agencies retain information? How long should social media sites retain information? Are there different laws dealing with their retention policy? Archive Social Media is a third-party company that handles archiving social media content. That way, if necessary, you can search back old files. Archive Social websites state that software is compliant with many regulations, like SEC, Freedom of Information, federal rules on civil procedure, SOX, and so forth. To comply with laws such as these, companies might be required to keep posts and comments 3 to 5 years, or longer depending on the type of information. Storage in the cloud, like Google Docs or OneDrive. Users can share and modify documents. How does this deal with retention? Also, how does this deal with privacy when organizations like OneDrive, iCloud, or Google Docs, the parent company, may have the right to view the content that you're posting in their cloud? Benefits is you can copy files there. You can always have access to them. But again, privacy can be an issue. If an employee can access a personal file, what can you upload there? Also, what could Dropbox view? So personal files will be intermingled with company files, and this may or may not be okay. Companies should create policies explaining the needs to store personal files and keeping them private, and how they may differentiate between company files. Small business owners should also be cautioned when using cloud storage. Small business might be able to afford only smartphone accounts and one computer. So instead of having separate accounts, they may have a home and business account all kind of combined into one. If one device is compromised, both are. So any litigation would apply to both types of devices. So even though it may be a corporate dispute or a business dispute, they may be able to gain access to personal information. We have what's called an Event Data Recorder, EDR, and this is technology used for airplanes like their black box, and how it's able to record data. We also have one for cars. The National Highway Transportation Safety Commission has proposed legislation making them mandatory. That way you could pretty much have a black box for your car. According to the National Highway Transportation Safety Committee, access to this information is not intended to be invasive of the privacy, but more about security and protection of everyone. EDRs will offer safety improvements, as they also introduce more legal issues. Emerging trends, again, depending on the organization you're dealing with, are how privacy laws are now affecting the online component to a lot of these businesses. Looking at new ways to sift through huge amounts of data within litigation is also becoming a concern. What about things like anti-forensics within e-discovery? Deliberate destruction or concealment of evidence is always a possibility, though more common in criminal cases. Civil attorneys should become as informed about digital forensics as a criminal prosecutor should. They should learn about the methods used. They should also understand anti-forensic techniques, such as methods of deleting, altering, or hiding evidence to obstruct digital forensics investigations. In a civil case, evidence of anti-forensics activity is usually deemed the spoliation of the courts. These actions are subject to court sanctions. In a criminal case, evidence of anti-forensics is usually used to support the prosecution's claim of criminal activity. They could be methods such as emptying the recycle bin, deleting files. It could also look at understanding or manipulating hard drive characteristics, manipulating files, folders, or data on a hard drive, damaging the hard drive so data is not recoverable, so forth. If discovery material is believed to have been deleted or altered, try to get a forensics image of the hard drive so a forensics investigation can take place. Emptying a computer's recycle bin doesn't destroy the information. The data is still there. It's just a matter of using forensics tools to recover the data. Files aren't actually deleted when you delete them. They're still on the hard drive. You really just delete the link to that file. With the appropriate forensics tools, you can recover files. You can recover emails in the form of PSTs and OSTs. Because again, as you delete the file, or you delete the data, it's actually not there. You delete the index card, essentially. If you're looking at like a library system, the book's still in the library, it's just you don't know where in the library it's at because you deleted the index card. The process of deleting an email changes the file's first 8 bits to straight hexadecimal versions of F. And it's there until new data overwrites it. And that is the end of this chapter. We talked about the ECP, we talked about the SCA, multinational corporations and laws may affect different areas. We talked about different iOS standards and the new standard try to standardize forensics discovery. We talked about data retention and anti-forensics technology. If you have any questions, please reach out. Please let me know. Thank you. Have a great day.